Welcome, debtors and borrowers, to Bankruptcy Bailout, because debt ruins lives, not bankruptcy. My name is Matt Burkus. I'm a Colorado-based bankruptcy and student loan relief attorney. And in today's topic, we're going to be talking about what student loans can be discharged in bankruptcy. So this is going to be somewhat of a deep dive into the technical definition of what is a student loan and what isn't a student loan. One thing we won't be covering is what's called the undue burden analysis to discharge student loans in bankruptcy. So let me set a little context here first. So under the Bankruptcy Code, student loans are what we call presumptively non-dischargeable. So if you have a student loan, all right, it's not going to be, and you file bankruptcy, it's not going to be discharged in your bankruptcy just like a credit card debt or a personal loan or most other types of debts that can be discharged in bankruptcy. You have to take an extra step, which is file what's called an adversary proceeding, which is a lawsuit against your student loan servicers, and prove that repaying your student loans would create an undue burden, would create an undue burden. Okay, so we're not talking about the undue burden analysis. So what we're going to be talking about is that there's types of student loans that are presumptively non-dischargeable, and the types of student loans, and there's some types of student loans that can be discharged in bankruptcy. Now, what I say is that student loans are presumptively non-dischargeable. Okay, so again, you can prove undue hardship, and there's other technical defenses against student loans in order to get them eliminated in bankruptcy. Now, we often talk about student loans in terms of federal student loans and private student loans. However, the legal definition of a student loan is called a qualified educational loan, and that's what the Bankruptcy Code uses. Now, the Bankruptcy Code itself doesn't define qualified education loan. That is defined actually in the Internal Revenue Service Code. All right, so let's take a look at the definition. So a qualified education loan is a loan that means an indebtedness incurred by the individual solely to pay qualified higher education expenses, which are incurred on behalf of the individual or their spouse or dependent of the individual at the time, or as of the time the indebtedness was incurred, which are paid or incurred within a reasonable time before and after the indebtedness is incurred, and which are attributable to education furnished during a period during which the recipient was an eligible student. So let's break down that definition a little bit. So in order to be a qualified education loan, the proceeds have to be used for qualified education expenses, and we'll talk about what that is in a second. All right, and then it also has to be incurred within a reasonable time. So basically it has to be contemporaneous with when the student is going to school. Okay. Now, I've never seen this situation before, like outside of that, because usually if you incur a student loan, you're doing it right at the time. But I mean, I guess theoretically, if say your parents borrowed $50,000 when you're age 16 to send you to college, and you didn't go to college until you're 18 and a half, well, whatever loan that $50,000 is would not be considered a student loan or a qualified education loan, because it wasn't incurred around the time that the student was an eligible student attending an eligible institution and paying for qualified higher education expenses. And then the last one was, okay, you have to be an eligible student, and we'll talk about what that is briefly as well. But the key one here, and what distinguishes the different types of loans, are qualified education expenses, and this relates to cost of attendance. Now, don't get your hopes up here, because qualified education expenses is pretty much just about everything. Okay, so in the definition of qualified education expenses, obviously it refers to tuition and fees. It's basically everything that a student would have to pay in order to attend that university. So it includes, as I said, tuition, fees, housing, food, telecommunication, technology, dependent care if you happen to be a parent. Heck, it can even cover things like license fees for after you're done. So for example, for a law school, part of the qualified education expense may be your state bar application fee in order to get your license to practice law. So qualified education expenses is pretty much everything you can think of, and it also includes living expenses as well while you're in college. And then there has to be a qualified educational institution. Okay, so bottom line there is, so long as the institution is eligible to receive federal financial aid, it's going to be an eligible institution. Okay, so if the institution is not eligible to receive financial aid, and you may run into this with some trade schools most often. If they're not eligible, then most likely, if you got some sort of loan to attend that certificate program or school, it's not going to be considered a qualified educational loan. So like these coding academies, I've seen a few of those. Coding academies, truck driver schools, another one. A lot of trade schools, a lot of these for-profit schools that went belly up. And although some of those were eligible to receive federal financial aid, but probably shouldn't have. Anyway, so again, there's going to be these niche areas where you might not have a qualified education loan based on where you attended school because they weren't eligible to receive financial aid. And then finally, eligible student basically just means you're attending at least half-time. It has to be exclusively post-secondary, okay? So if you're in a dual enroll program where you're in high school and college at the same time, all right, and for some reason, if there's a loan involved in there, that's not a qualified education loan. So it has to be exclusively for post-secondary education, and you have to be pursuing a recognized education credential. Now, that's all fine and good, so qualified education expenses, qualified institution, eligible student. The thing is, 98% of the time, all those categories are going to be satisfied, especially if you're attending a regular college, regular graduate program, professional degree. So whatever money you borrow is going to be considered a qualified education loan. But not all hope is lost here, all right? So the key factor in whether the loan is dischargeable in bankruptcy or not is whether it conforms to your school's cost of attendance. And again, this relates back to the qualifying educational expenses. And you see this more with graduate programs because these tend to be older students. They're independent students. They may be married, so they may borrow more money than what the school is authorized as far as their cost of attendance. All right, so again, you have this cost of attendance, which is supposed to be everything you need. Now, but if you borrow money, if you're able to borrow money in addition, on top of that cost of attendance, that portion is what we call an uncertified private student loan, and that can be directly discharged in bankruptcy. So when it comes to private student loans, you're going to have certified private student loans and uncertified private student loans. Certified private student loans are going to be subject to the cost of attendance cap. So let's say you're going to medical school first year, the cost of attendance cap is $140,000. I mean, I'm just pulling random numbers. I don't really know the numbers, but that sounds about right based on the doctors I know and the amount of student loans they have. So let's say it's $140,000. Now you get the maximum federal student loans you can get. You get some private student loans that are subject to the cost of attendance, but you go out and borrow some more money. Now, the lender and you may be calling those private student loans, but since the money is paid to you directly, or to the student directly, it doesn't flow through the school, and since the amount of money exceeds the accepted cost of attendance established by the school, that is an uncertified private student loan and therefore is not a qualified education loan under the IRS code, and therefore not a qualified education loan under the bankruptcy code and would be dischargeable in bankruptcy. All right. Now, federal student loans are always going to be subject to the cap. You can never really borrow federal student loans that are going to exceed the cap. So you're never going to have this issue come up, or this cost of attendance issue come up with federal student loans, but you do see it sometimes with private student loans where you need to borrow more money than what the school's cost of attendance or what the school has established as the cost of attendance. All right, so those loans can be discharged in bankruptcy. Qualified education loans are presumptively non-dischargeable, and you have to go through and meet the criteria. So there's still this cascade of analysis that takes place. So, A, do you have a student loan? All right, okay, maybe you do. Qualified education loan. All right, did you borrow it at the time? Did you borrow the money at the time you went to school? Or did it go into repayment around the time you got out of school? All right. Did you use it to pay for, or was it for qualified education expenses? And basically all that means is it within your school's cost of attendance cap? And were you an eligible student, which means you were attending at least more than half time, pursuing a recognized education credential, and you were exclusively enrolled in post-secondary education. Again, 98% of cases, unfortunately, yeah, that's probably a qualified education loan, but we do see occasionally these little niche issues that you have to look out for that kicks out the debt out of being a qualified education loan. And again, you see this more especially when it comes to eligible student or eligible institution. Again, if the institution is not eligible for federal financial aid, then no loan for that institution is going to qualify as is going to qualify as a qualified educational loan. Sometimes you see issues with the eligibility of the student to attend, and that can go beyond just the basic qualification there, but that's a different defense to student loans. All right, so there's a defense to student loans you can raise with the Department of Education directly about whether you should have been enrolled in school in the first place. And this has to do with whether you can benefit from the program. So, for example, if a college enrolls someone who didn't graduate from high school, you might be able to get your loans kicked out of being qualified education loans because they're not going to be able to benefit from the program. There was no reasonable way that they were going to complete the program because they really just weren't eligible to attend. But that's a different issue. Anyway, so this has been somewhat of a deep dive into the cascade analysis that you have to go through to make sure you have a qualified education loan that would be presumptively non-dischargeable, and to determine whether your student loans can be discharged in bankruptcy or not. My name is Matt Burkus. Again, I'm a bankruptcy attorney in Colorado. I offer free initial consultations to the residents of Colorado for the purposes of bankruptcy, and I offer paid consultations to people nationwide to discuss their student loan issues and to help them with student loans. Best of luck.